Hi guys! Welcome to another episode of Attorney Javier Law Vlog. Today we continue with our discussion on the Intellectual Property Code, and today we'll be talking about the law on trademarks. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, the law on trademarks is found in the Intellectual Property Code, otherwise known as Republic Act No. 8293 as amended. Being an intellectual creation, it is one of the modes of acquiring ownership. Now, a mark in general may be a word mark, such as a full name, like Hugo Boss. It may also be a first name, such as in the case of Ben and Jerry's Ice Cream, which stands for Ben Cohen and Jerry Greenfield. The mark may also be a surname like Armani, or even the joining of a name, such as in the case of Adidas, which stands for Adi Dassler. A mark may also be a composite mark, meaning a combination of a word or words, or letter or letters, and a device, such as in the case of BMW, where the letters B, M, and W are enclosed within a circle, and beneath those letters there is a smaller circle with 4 colored quadrants enclosed in that smaller circle. Now, a trademark is any visible sign capable of distinguishing the goods of an enterprise, and that would include a stamped or marked container of goods, such as in this case of the container for Cadbury ice cream. This serves as the container of the ice cream, and upon it contains the mark Cadbury to indicate the origin or ownership of the mark, specifically Cadbury. If the mark is used to distinguish services, then it is called a service mark. Now, a trademark is different from a trade name, which refers to the name or designation identifying or distinguishing an enterprise or its goodwill. When we say goodwill, that is a property right, and it may be defined as the established reputation of a business regarded as a quantifiable asset, meaning it is measurable. And how do we measure it? It is represented by the excess of the price paid at a takeover of a company over its fair market value. So the trade name refers to the business and goodwill, while a trademark refers to the goods. Now, we also have a collective mark, which means any visible sign capable of distinguishing the origin or any other common characteristic, including the quality of goods or services of different enterprises which use the sign under the control of a registered owner of the collective mark. So it's like an umbrella. There is the registered owner, the registrant, and there are different enterprises using his mark. So that's collective mark. But for the purposes of our discussion today, I will be referring to all those terms collectively as trademark, just to facilitate our discussion. Now, trademarks perform several functions, such as they indicate origin or ownership of the goods, they assure the public that they are procuring the genuine article, so it's to prevent fraud, also to protect the manufacturer against substitution and sale of an inferior and different article than his product. Another function would be to advertise the articles they symbolize. Specifically, not only do trademarks symbolize the origin and goodwill, but they often serve as the most effective agent for actual creation and protection of goodwill. Why? Because these marks imprint upon the public mind an anonymous and impersonal guarantee of satisfaction, creating a desire for further satisfaction. In other words, the mark, by purchasing the ice cream bearing the mark Cadbury, and I am satisfied with the product, I have associated in my mind the quality with the mark. And when I see that mark again on similar goods, that creates a desire for further satisfaction in me to further buy the goods bearing the mark Cadbury. Okay? So in that case, the mark actually sells the goods, thereby becoming the silent salesman. And therefore, the mark in this sense has become a more convincing selling point than even the quality of the goods to which they refer. However, the most important function of a trademark is to serve to secure the fruit of labor and skill to the person who brought a superior article of merchandise into the market. And how does a trademark do this? Under Section 147, the owner of a registered mark shall have the exclusive right to prevent all third persons from using signs or containers for goods or services in the course of trade which are identical or similar to those owned by the trademark owner without his consent, where such use of the mark by the third person would result in a likelihood of confusion. And that likelihood of confusion shall be presumed in case of the use of an identical sign for identical goods and services. Okay? In short, the trademark owner of Cadbury can prevent other persons who want to use the same mark on their goods. Okay? He can prevent them from using that mark without his consent, especially in the case where the use of his mark would cause confusion. They would confuse the public that the marks used by the third person belong to Cadbury when in fact they do not. Okay? So in this regard, the trademark owner can take action to protect his rights by preventing or punishing violations of his trademark rights. Take note that what the law only requires is that the marks used by the third person without the owner's consent will cause a likelihood of confusion, which is presumed if the mark is used for identical or similar goods. Like the mark Big Mac is used on hamburgers from McDonald's, and Big Mac is also used from burgers from LC Big Mac. Okay? So there is confusion because they sound the same, Big Mac. I'll talk about that case when I get to the topic on infringement. Now, these rights to prevent third persons that I mentioned earlier, they also apply to marks which are not registered in the Philippines but are well-known marks, okay? Because as a general rule, the protection only extends to marks which are registered. However, the protection will also extend to marks that are not registered in the Philippines but are well-known marks. And what are well-known marks? Those which have been determined to be well-known internationally and in the Philippines. To determine if a mark is well-known, we take into account the knowledge of the relevant sector of the public and not the knowledge of the public at large. Meaning, that sector which is familiar or actually patronizes the goods or services, and we include knowledge in the Philippines which has been obtained as a result of promotion of the mark. With regard to the rights of the owner of a well-known mark, the protection offered by the law will depend if such well-known mark is registered or not in the Philippines. If the well-known mark is not registered in the Philippines, then the owner of the mark has the right to prevent third persons from using identical or similar marks on goods or services which are identical or similar to those of the trademark owner. So for example, there is a well-known mark abroad for shoes. Let's just say Mikey, okay? It's a well-known mark abroad for shoes, and that mark is not registered here. Now, there is a third person here in the Philippines that wants to and actually uses the mark Mikey for his own shoes. Okay? He makes shoes, let's say, in Marikina, and then he applies the mark Mikey. But Mikey abroad is not registered here in the Philippines. Can the owner of the mark abroad be protected from the use of the mark by the Filipino? Yes, okay? The owner of the mark has the right to prevent that third person from using the mark on his shoes because they are identical or similar goods. Now, that is in case the well-known mark is not registered in the Philippines. But if the well-known mark is registered in the Philippines, then the right of the owner is now bigger, okay? The right of the owner to prevent third persons from using identical or similar marks on goods or services now extends not only to goods or services which are identical or similar to those of the trademark owner, but also to goods and services which are not similar or those that are unrelated. Okay, so even to unrelated goods. So using the example earlier with the well-known mark Mikey referring solely to shoes, definitely, as I said earlier, the owner of the mark can prevent third persons from using his mark without consent in case the mark is used on shoes because they're similar or identical goods. But the well-known mark, the owner of the well-known mark, if he registers that mark in the Philippines, now he can prevent third persons from using that mark even on unrelated goods. So let's say that the third person wants to put the mark Mikey on, let's say, watches, no? Or let's say socks, okay? So in that case, the right of the third person, or the right of the owner of the well-known mark to prevent the third person from using his own mark, okay, now extends to unrelated goods as well. However, the law requires compliance or proof of the following. First, there must be proof that the use of the mark by the third person on his goods or services would indicate a connection with the goods or services of the true owner. Okay? So, in my example earlier, the use of the third person in putting the name Mikey on socks, no? That might create confusion on the part of purchasers to think that, hey, is Mikey now expanding its business from shoes to include now also socks? Okay? So there is now a connection. Second, the thing that must be proven is that the interests of the owner of the registered mark are likely to be damaged by the use of such mark. Okay? Now, a mark can also become well-known through exclusive and continuous use for a long time. Which now brings us to the doctrine of secondary meaning, which is also known as the doctrine of distinctiveness of trademarks and names. And this doctrine simply states that while technically the mark should not have been registered because it is geographical, descriptive, or is a surname which cannot be registered, no, all those, the exclusive and continuous use for a long time of a mark or name such that that mark or name has lost its primary meaning and now becomes associated in the public mind with particular goods, now entitles the user to have said name or mark registered with the IPO. Put differently, a word or phrase originally incapable of registration because it is geographical or otherwise descriptive might nevertheless have been used for so long and so exclusively by one producer with reference to his goods that in the trade and to the group of the purchasing public, the word or phrase has come to mean that those goods are his product. Okay? Let's say it's been in use since 1800s, no? And there is no doubt in the mind of the public that those goods came from this producer. Okay? So that is the doctrine of secondary meaning. The mark or the name has now acquired a secondary meaning in the mind of the public that such product is belongs to or comes from this certain producer. Okay? To be able to invoke this doctrine of secondary meaning, there must be evidence that the business has continued for so long a time that it has become of consequence or relevant and has acquired goodwill of considerable value such that its articles and products have acquired a well-known reputation, so that use of the disputed name by others will result in confusion. So to summarize, the owner of the trademark can prevent others from using signs which are identical or similar to his own mark, which signs are likely to cause confusion on the buying public. So the law on trademarks protects the trademark owner from infringement and unfair competition, which I'll talk about in the next episode. Okay? And how long does this protection last? The duration of trademark registration and its protection is for 10 years. And this is renewable for periods of 10 years for each renewal. And in order to renew the protection, the request must be made within 6 months, either before or after the expiration of the registration. So how are these rights acquired? Rights in a mark shall be acquired through registration with the Intellectual Property Office or the IPO, while rights over a trade name are acquired through adoption and use. Again, rights in a mark acquired through registration. Rights to a trade name simply through adoption. You adopt the name and you use it. Okay? Now let's get the rules on trade names out of the way first. So the law gives us restrictions on the use of trade names, prohibiting the use of names which are contrary to public orders or morals, or if they are liable to deceive trade circles or the public as to the nature of the enterprise identified by that name. While a party may register his trade name with the IPO, registration is not required for said party to enjoy the protection of the law. Section 165.1 paragraph B says that any subsequent use of the trade name by a third person, whether as a trade name, trademark, or collective mark, or any such use of a similar trade name or mark which is likely to mislead the public, shall be deemed unlawful. And the remedies for infringement or unfair competition in case of trademarks likewise apply to infringement or unfair competition in case of trade names. And I will discuss the remedies later or in the following episode, okay? Now, of course, even if registration of a trade name is not required, it is still preferable to register the trade name with the IPO. Moving on to trademarks. As I mentioned, rights over a mark are acquired solely through registration. Now, it is entirely possible that an applicant for registration may have previously filed an application for registration of a mark abroad in a different country. Then later on, he may file an application for registration of the mark in the Philippines. Why will he do that? Let's say he wants to be protected first in that country where he first registered, but he also wants to be protected here in the Philippines. In such a case, the applicant may claim a priority right. Okay? Take note of priority right, which simply means that his application will be considered as filed as of the day the application was first filed in the foreign country, but only if the country where he had earlier filed his application either is a party to any convention, treaty, or agreement relating to intellectual property rights or the repression of unfair competition to which the Philippines is also a party, or is a country that extends reciprocal rights to nationals of the Philippines by law before having filed for registration in the Philippines. In such case, the application for registration of a mark in the Philippines will not be granted until the application for registration of the mark has been granted in the country where the application was first filed. However, take note that just because a party may have a priority right, that does not mean he can already sue for violations of his right committed before his registration is granted in the Philippines, okay? What he can do, however, against an identical or confusingly similar mark is to oppose its registration, or he can also petition the cancellation of its registration, or he may also sue for unfair competition without prejudice to availing himself of other remedies provided for under the law when his registration is granted. Take note, however, and this is very important, that registration by itself, no, the mere act of registration and the grant of registration, by itself, it does not necessarily vest ownership in the mark, especially where it is proven that someone else is the true and actual owner of the mark, as what happened in the 2013 case of Birkenstock versus Philippine Shoe Expo Marketing Corporation. In 1994, Birkenstock, Germany, no? It's actually a long name, Birkenstock, Orthopädie, whatever, but well, I'll call it Birkenstock, Germany. It applied for registration of its mark Birkenstock, but here in the Philippines, but the proceedings were suspended because it was found that the mark was previously registered in the Philippines by Philippine Shoe. In affirming the decision of the IPO Director General and allowing the registration of the mark in favor of Birkenstock Germany, the Supreme Court said that Birkenstock Germany has duly established its true and lawful ownership of the mark, especially since it has been using the mark since the 1800s, okay? While indeed, Philippine Shoe was the first to register in the Philippines, registration by itself is not a mode of acquiring ownership, especially if the applicant is not the owner of the trademark. Then he has no right to apply for his registration. Registration merely creates a prima facie presumption of the validity of the registration, the registrant's ownership of the trademark, and the exclusive right to the use thereof. But take note that that is only a presumption, and such presumption may be rebutted and must give way to evidence to the contrary. So it is not the application or registration of a trademark that vests ownership, but it is the ownership of a trademark that confers the right to register. Okay? Because you are the owner, you can register. Not the other way around. Okay? A trademark is an industrial property over which its owner is entitled to property rights which cannot be appropriated by unscrupulous entities that in one way or another happen to register such trademark ahead of the true and lawful owner. The presumption of ownership accorded to a registrant must yield to superior evidence of actual and real ownership of a trademark. The ownership of a trademark is acquired by registration and its actual use by the manufacturer or distributor of the goods made available to the purchasing public. So in other words, the prima facie presumption of ownership created by registration of a mark may be challenged and overcome by evidence of prior use by another person because a trademark is a creation of use and belongs to the one who first used it in trade or commerce. So with Birkenstock having been shown to be the true and lawful owner of the mark, especially as shown by its origin, history, and use in commerce long before the registration by Philippine Shoe, then Philippine Shoe was found to have been in bad faith in registering the mark in its name. So the Supreme Court ruled that Birkenstock is entitled to have the mark Birkenstock registered in its name. So now, let's say you want to have your mark registered. What can you do to ensure that your application won't be denied outright? You make sure that your proposed mark is not prohibited by law. Same with trade names earlier, Section 123 provides for restrictions on what marks can or cannot be registered. Okay? And this list is actually very long, so I will go through them very briefly. A mark cannot be registered if it consists of immoral, deceptive, or scandalous matter. Let's say mutilation, incest, murder, etc. That cannot be registered. Okay? Next, if it may disparage, falsely suggest a connection with, or create contempt or disrepute upon living or dead persons, institutions, beliefs, or national symbols, especially since this may border on libel, okay? So you cannot create a mark which will disparage a person. You cannot falsely suggest a connection with another person, living or dead, okay? The next prohibited matter would be the flag, coat of arms, other insignia of the Philippines or its political subdivisions, or for any foreign nation or simulation thereof. Because of course, no one person can own a trademark over the flag. The flag would belong to the Philippines or whatever nation it refers to. The next prohibited matter would be the name, portrait, or signature identifying a particular living individual, okay? Except by his written consent. So let's say you want to trademark the signature of Manny Pacquiao, definitely you cannot because that is not your signature. You have no rights over it. But if you are able to acquire the consent of Manny Pacquiao, then you may trademark his signature. Next, the name, signature, or portrait of a deceased president of the Philippines during the lifetime of his widow, if any, except by written consent of the widow. Okay, so here the president is already deceased. So of course, you cannot obtain his consent. But the law allows you to trademark the signature or name or portrait of the deceased president provided the widow gives her consent, okay, written consent. Next prohibited matter is identical with a registered mark belonging to a different owner or proprietor, or a mark with an earlier filing or priority date with respect to the same goods, closely related goods or services, or if it nearly resembles such a mark as to be likely to deceive or cause confusion. So of course that will be prohibited because you're practically asking for registration of a mark that will infringe an existing mark, especially for closely related goods or the same goods, no? Next, registration will be prohibited if the mark is identical with or confusingly similar to or constitutes a translation. Take note, translation is included, such as in the case of Jollibee. You're making it now Masayang Bubuyog. Okay, that will not be allowed. So, prohibited matter includes a mark which is identical, confusingly similar to, a translation of a well-known mark which is already owned by someone else. Okay? So remember my discussion earlier. If the well-known mark is registered here, then the prohibition extends to both identical and similar goods as well as to unrelated goods, provided that the use of the mark establishes a connection among the goods and is likely to cause damage to the owner of the mark. If it is not registered here, then the prohibition extends to identical or similar goods or services only. Next prohibited matter. If the mark is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographical origin of the goods or services. Like, let's say, 24 karat gold, when what you're selling is of different grades, no, like 10 karat, etc. Okay, so it can mislead the public that you are actually selling goods of this quality. Okay, another, if it consists exclusively of signs that are generic for the goods or services that they seek to identify, like cup for cups, or shoe for shoes, pencil for pencils, and the list goes on, no? If they're generic or descriptive, no? Because you cannot trademark the word shoe for your brand of shoes, okay? Next prohibited matter, if it consists exclusively of signs or indications that have become customary or usual to designate the goods or services in everyday language or in bona fide and established trade practice. Next, if it consists exclusively of signs or indications that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time or production of the goods or rendering of the services, or other characteristics of the goods or services. An example is found in the case of Asia Brewery versus CA, wherein Beer na Beer was held not to infringe or unfairly compete with San Miguel Pale Pilsen. Okay? Among others, no, but just for this particular discussion, the Supreme Court held that the words Pale Pilsen okay, do not constitute infringement or unfair competition because the words are merely descriptive, with the word pale describing color and Pilsen referring to a light Bohemian beer with a strong hops flavor that originated in the city of Pilsen in Czechoslovakia and became famous in the Middle Ages. Okay, so the prohibitions I mentioned earlier, no, they consist of signs or indications of geographical origin, etc. Okay, so those are not capable of registration. Next matter consists of shapes that may be necessitated by technical factors or by the nature of the goods themselves or factors that affect their intrinsic value, and consists of color alone unless defined by a given form. So with regard to shapes or color, take note that even though in general these cannot be registered, if such sign or device has become distinctive in relation to the goods as a result of the use that has been made of it in commerce in the Philippines, then such color or shape may be registered. Okay, it depends. It will depend on the Supreme Court or the IPO, no? So, proof of substantially exclusive and continuous use in commerce in the Philippines for 5 years before the date on which the claim of distinctiveness is made is prima facie evidence that the mark has become distinctive. Now, the case of Asia Brewery versus CA can once again be used as an example with regard to colors and shapes. Because here, again, what was being contested was the use of beer na beer against San Miguel Pale Pilsen. Okay, and the Supreme Court said that the use of the amber's tiny bottle, you know, the bottle shape of the Pale Pilsen, no? While similar, okay, while the use is similar, is not unlawful because the bottle size, shape, and color may not be the exclusive property of any manufacturer. In fact, the color itself serves a functional use because amber is the most effective color in preventing transmission of light and thus provides the maximum protection to beer. So a merchant cannot be prevented from using a type or color of bottle where the same has a useful purpose of protecting the contents from the deleterious effects of light rays. Moreover, no one may have a monopoly on any color. It's not only beer, but most medicines, whether in liquid or tablet form, are sold also in amber-colored bottles. Also, the capacity of 320 milliliters was not due to a desire to imitate, but at the time, it was the standard prescribed under a Department of Trade circular. So for these and other reasons, there was no infringement or unfair competition. The final prohibition refers to marks which may be contrary to public order or morality. So what if an applicant creates a mark that is partly valid and partly non-registrable because it falls under any of those prohibitions? Well, under Section 126, if he wants to proceed with the application, he should disclaim the unregisterable component and simply proceed with the valid portion. So, once all the steps for registration have been completed, a certificate of registration may be issued to the applicant or his assignee, and such certificate shall be prima facie evidence of the validity of the registration, the registrant's ownership of the mark, and the registrant's exclusive right to use the mark in connection with the goods or services, and those that are related thereto as specified in the certificate. Remember what I said earlier in the Birkenstock case, that registration without more does not give the registrant an absolute right to the mark. The certificate of registration is merely a prima facie proof that the registrant is the owner of the registered mark, and evidence of prior and continuous use of the mark by another can overcome the presumptive ownership of the registrant. Ownership of a mark may be acquired not necessarily by registration but by prior adoption, okay, and use in trade or commerce. Take note of this, as between actual use of a mark without registration and registration without actual use, it is the former that prevails over the latter. Take note that prior use is no longer a condition for the filing of an application. However, under Section 124.2, the applicant needs to file a declaration of actual use of the mark with evidence to that effect within 3 years from the filing date of the application. And if he does not file, then the application shall be refused or the mark shall be removed from the register. Then take note of Section 145. The registrant shall once more file a declaration of actual use and evidence to that effect, or shall show valid reasons based on the existence of obstacles to such use within 1 year from the 5th anniversary of the date of the registration of the mark. So, before the 6th year. Okay? Otherwise, the mark shall be removed from the register by the office, by the IPO. Now, if the IPO can grant registration, it can also cancel registration. So, any person who believes that he is or will be damaged by the registration of a mark may file a petition for cancellation of that mark either within 5 years from the date of the registration of the mark or at any time in the following cases. Okay? So, 5 years from the date of registration or at any time. And these are the cases which fall under any time. No? First, the registered mark becomes the generic name for the goods or services or a portion thereof for which it is registered. Second, if the mark has been abandoned. Third, if the registration was obtained fraudulently or contrary to law. Fourth, if the registered mark is being used by the registrant or with the permission to misrepresent the source of the goods or services. Or fifth, if the registered owner of the mark without legitimate reason fails to use the mark within the Philippines or to cause it to be used in the Philippines by virtue of a license during an uninterrupted period of 3 years or longer. Okay, so failure to use within 3 years. However, take note that under Section 152, non-use of a mark may be excused if it is caused by circumstances arising independently of the will of the trademark owner. Okay, it's out of his hands, no? However, take note also that lack of funds, wala siyang pera, that will not be an excuse for non-use of the mark. Okay? So that's it for part 1 of the discussion on trademarks. Please wait for the next episode where I'll talk about infringement and unfair competition. So I hope you may have picked up a thing or two, and I hope to see you next time, guys. Okay? See you soon. Bye.